against a uniform definition of maritime piracy. Many scholars argue that a major obstacle to eradicating the global problem of maritime piracy is the lack of a uniform definition of piracy. Their chief concern is that without a uniform definition, it is difficult to formulate responses on a systemic and global level. This article contends that having multiple definitions of piracy for different purposes is conducive to combating piracy and addressing the ensuing legal issues. While uniformity between certain definitions should be pursued, complete uniformity should not be adopted due to the multiple purposes the definition of piracy serves. This article categorizes the definition of maritime piracy according to four respective purposes: public international law, domestic criminal law, commercial law, and piracy prevention. It demonstrates that uniformity is important between the first two purposes due to the need to uphold rule of law principle. However, this definition should not be uniform with regard to the definition for the last two purposes due to the need for flexible and expansive definition in commercial law and piracy prevention. Maritime piracy has been a growing international plague in recent years. Many scholars lament that a major obstacle to eradicating piracy is the lack of a uniform definition of the phenomenon. Their chief concern is that without a uniform definition, it is difficult to formulate uniform responses on a systemic and global level. This article argues that having multiple definitions of piracy is, in fact, conducive to combating piracy and addressing the ensuing legal issues. While uniformity between certain definitions should be pursued, complete uniformity should not be adopted due to the multiple purposes the definition of piracy serves. This article categorizes the definition of maritime piracy according to four respective purposes: public international law, domestic criminal law, commercial law, and piracy prevention. It demonstrates that uniformity between definitions is important as regards the first two purposes, public international law and domestic criminal law, due to the need to uphold rule of law principle, including legality, legal certainty, predictability, and non-arbitrariness when dealing with suspected pirates. However, this definition should not be harmonized with those for the last two purposes, commercial law and piracy prevention, due to the need for flexibility and expansiveness. In commercial law, the definition of piracy only impacts private interests and the allocation of liability in the aftermath of pirate attacks. An expansive definition is therefore justified as long as the parties are in agreement. Finally, for the purpose of piracy prevention, an over-inclusive definition that can capture all forms of piracy is essential because the objective is to reduce or eliminate attacks regardless of whether they meet the traditional narrow definition of piracy. The article first examined the existing debate on whether there should be a uniform definition of piracy. It then discussed the four different definitions of piracy and their respective purposes and explained why uniformity is desirable only between the definition of piracy in public international law and domestic criminal law and not for the definition in commercial law and prevention, as complete uniformity would make the definition overly restrictive and consequently frustrate the latter two purposes. The article concludes that despite cautioning against complete uniformity, partial uniformity is still a worthwhile goal. Debate on uniformity. Scholars have long debated the various definitions of maritime piracy and the lack of uniformity. This lack of a uniform definition of piracy raises the issue that an act may be defined as piracy using one definition but not under another because many modern forms of piracy fall outside certain existing definitions. This is especially concerning because the most widely accepted definition of piracy found in the United Nations Convention on the Law of the Sea or UNCLOS use a narrow definition that excludes many acts of modern piracy. A short introduction on the scope of modern piracy is thus in order. Modern piracy, unlike classical piracy on the high seas, manifests itself in various forms depending on the region and adapts to modern technical, political, economic, and social development. It ranges from petty larcenies in territorial waters to sophisticated criminal syndicates whose goal is to capture the vessel itself. Today, there are three major hotspots of piracy: East Africa, West Africa, and Southeast Asia. One characteristic generally present across the board is the use of modern technology to plan and execute the attack. In East Africa, the use of sophisticated weapons to hijack ships and hold the crew hostage has been the prevalent mode of operation. Operating off the coast of Somalia, in the Gulf of Aden, and in the Horn of Africa, piracy attacks often involve the launching of small skiffs from larger motherships, which are usually vessels they previously hijacked. Harm to the crew has been relatively minimal because the primary motivation has been to extort ransom payment in exchange for the hostage. For now, Somali piracy is largely contained due to the international response to the problem, including United Nations and European Union naval convoys, UN Security Council resolution allowing ships to enter Somali territorial waters, effective prosecution, and vigilance by the shipping industry in hiring armed security personnel and following safety protocols. Nigerian piracy, occurring in the region spreading from the inland waters of Nigeria to the waters off the coast of Benin and Togo in the Gulf of Guinea in West Africa, has been characterized by greater incidence of violence, with the highest number killing compared to other regions. The attack centered on armed robbery and theft of cargo, particularly oil. There is evidence that the tanker oil theft are being facilitated by corrupt officials, and the pirate often claim to be redistributing the wealth generated by the oil trade, which adds a political dimension to the attacks. Piracy in Southeast Asia has long differed from the traditional Western, classical notion of piracy that has dominated the international dialogue. The two most common types of attack historically were nighttime theft of property on board ship berthed in port and the stealing and selling of phantom ships after repainting and reflagging them, but oil theft is also a growing concern. The attack occurred in the South China Sea and the territorial waters of Singapore, Malaysia, and Indonesia in the Strait of Malacca. Some industry experts have claimed that many acts of purported piracy in this region are actually inside jobs designed to perpetrate insurance fraud. In response to the inability of the traditional definition of piracy, as embodied in the UNCLOS, to capture all forms of modern piracy that do not occur on the high seas or have non-private motives, as described above, many scholars advocate for a uniform definition that is more holistic, expansive, and able to respond to all iterations of modern piracy. Though modern piracy may fall under one of the other definitions in public international law devised in response to the shortcoming of the UNCLOS, such as that of the Convention for the Suppression of Unlawful Acts against the Safety of Maritime Navigation, or the International Maritime Organization definition of armed robbery, the hodgepodge of definition could potentially yield a hodgepodge of uncoordinated responses. Thank you.